Awesome. So, welcome all of you who've joined this afternoon to talk about succession planning, and welcome Nitin and Archana. Thank you very much for agreeing to talk to us today about this topic. So, as part of wealth management in House of Alpha, we approach this holistically. We start from budgeting to looking at cash flows to looking at investments, and then deciding where to invest, and then moving on to insurances. And succession planning, of course, is a very critical element in the whole wealth management, comprehensive wealth management process. How is this asset going to be distributed without hassle? So we hear all kind of horror stories about, what happens to assets which are not properly designated. So this is a issue that we want to solve for our clients, but we don't really know how to. So we thought we'll rope you in as experts on this subject. So Harish, just to let you know, Nitin was referred to me by Shailesh Gadre, right? So you're friends from college or something like that, right, Nitin? So that's the connection. So they are people known in the industry, in the fraternity. So they come from very trusted referrals. We already did one session with Nitin and Archana back in the day, I think about 3-4 years back, when we were doing the 10 crore league. So it's welcome one more time, like coffee with Karan, second season, come back again. That's the thing. So very, very quickly, let me introduce Nitin and Archana. Archana Balasubramanian, she has over 16 plus years of experience in legal and compliance. She has a BLS LLB degree from the Government Law College. She's also a member of the Bar Council of Maharashtra and Goa and is a qualified non-practicing company secretary. Nitin has over 15 plus years of experience in legal and compliance and holds a BLS LLB degree from the Government Law College, as well as a LLM degree from the University of Mumbai. He also holds postgraduate diplomas in alternate dispute resolution, securities law, and cyber law. They do a lot of work in the corporate law space as well. Nitin and Archana, let us know a little bit about what's your interest in estate laws and in succession laws.
Sure. So I think estate and succession laws are generally, sort of straitjacketed into the area of wills. But we should look at it as an overall asset management or an asset protection kind of laws. And for us it is very important because we deal with a lot of HNIs. We do a lot of investments for them, in the sense that they invest in startups or they invest in other entities where they're going along with the fund, etc. So we do that part of it. We also advise a lot of the CXOs of large companies on how to, especially if they are at the age of sort of superannuation, etc., how to close out all their matters with their companies. So for us, estate and succession planning goes beyond, it could be something that you could do during the lifetime. That's what we do. And between me and Nitin, and there's also the trust. A lot of people want to create trust structures because trusts help ring fence their assets from a taxation and other perspectives. So this is where we come in. That's what interests us. We take care of all of this for our clients. And Nitin will speak about how they take care of post facto compliance of execution, of making sure that the right heirs kind of get their property. Over to you, Nitin.
Thank you, Archana, and thank you, Bhuvna, for a kind introduction. So way back 15 years, as a young law graduate, I landed up in a testamentary department in High Court, which I had no clue what testamentary means. And later on, I have realized it while reading and clearing exams in succession law and post-succession law reading, how it is really implemented in practical life. So when I went in testamentary department, executed certain wills as a probate obtaining, letter of administration obtaining, I realized that very few people who either construct the will or do not construct the will have no idea about it, that how the actual effect of the will comes into force, what are the legal nitty-gritties involved, what are the challenges faced by the legal heirs in case of untoward incident. And post that, over the years, I have seen certain family disputes. I have seen in the discrimination of the assets being not really have a good taste left for the legal heirs. And It leads to lot of disharmony. It leads to lot of disputes among the family members in the next generation. And these things have given us some kind of a experience for giving back to the society to understand and explain them more for what are the myth, what are the issues which are involved when it is pre and post, and how one should really plan what you have created over 5 decades, 6 decades, 4 decades, as to that should really a survive effectively, and b should be taken care by the legal heirs as blessings and not as really a pain. Basically, that's what my experience on the real estate and estate planning is.
Interesting. Very good. So what I hear you say is that Archana focuses a lot on the documentation and preparing the wills and the trusts, and you take care of the execution of the will. So you're saying that just making the will is not enough. It also has to be properly executed. That's what I'm hearing from you. Is that right?
Yes, hearing and the distribution as to how you really see it going forward post the untoward incident. Basically, what you have mind, what are your wish things, and whether will is a right instrument. While we are discussing all will here, I am slightly averse to the will practically, because some people, if have different types of assets with them, I may at the end of hearing their story say that you should not execute a will. There are enough instruments which are available for estate planning.
Oh, I see. Okay, that's interesting. So I'm very interested to know beyond will, succession planning beyond wills. So I'm going to just let both of you now and talk about this. I'd also like to know a few things here. One is what beyond wills, what other instruments? Of course, we had prompted to our clients based on your brief to that you would be talking probably about gifts and about family settlements and maybe trusts. So I leave it to you to brief us about it, and also touch upon what the rules are around movable properties and immovable properties, because I think there's a lot of confusion and lack of understanding on how the house devolves and how other assets as to FDs and mutual funds move. So just help us understand these things, just the basics for now, and then we can maybe take questions. So for all our guests who've joined, please put in your questions in the chat box, and I will ask them the questions and we'll get as many answers as possible. Yeah, so I'll let you guys handle this, and I'm right here.
Thank you, Bhuvana. So let me just start, Nitin, if it's okay, with a brief introduction of why we need to look at these issues of personal estate planning. See, it's not just about posthumous taking care of things posthumously, but it's also about protecting your present, the age when you are not going to be earning sort of earning money, so like post retirement, etc. So the planning has actually begins now. And as lawyers, we often wonder why somebody very young comes to us and says, oh, we want to write a will, but you don't even have properties today. So why do you need to write a will? So a lot of youngsters want to write a will, willing things to their wives, especially there's digital assets. So there are a lot of people who have a lot of digital assets, like they may be YouTube influencers. So who's going to get hold of their YouTube account after they pass? Things like this are often come to us. So let's understand this through a few different stories. I will, and the stories themselves will show you how different the situation was in each case, and what was the lack of thinking or the forward thinking that really helped. So the first is the story of a person who, when he started earning, he went abroad. He was the only person in his family who went abroad. So what he did is he came back and he gave he got a property with his father in his father's name, so that his father could handle the property. It was jointly owned by him and his father. Then a few years later, things happened where the younger brother started living with the father, younger brother and his wife. And whatever happened, the father's portion of it got willed to the younger brother. And the father passed away. In COVID, the younger brother passed away too. So this man who has invested in this property as a retirement planning, thinking that when I come back to India, this is the property in which I'm going to live, today is faced with a battle against the legal heirs of his brothers, whom he does not want to dislodge because obviously they are close to him. The woman has a son, she doesn't have a husband anymore. So he is left in a flux. So these are the kind of things where inter-family arrangements where things can go horribly wrong. Like this was a situation which was extremely difficult to unwind. Of course, we did do it one step at a time, but that's a very long story and it's a very highly technical story. But having said that, the anomaly can be seen. There are huge taxation impact, even if the other person were to gift the property to you. There are huge taxation impact similarly on relinquishment, which Nitin will dwell upon. So this is one situation. Second was the story of a man who retired and came to a town from the village, and he took up a house. What he did is he sold all his property while he was alive, and he bought one house which was good enough. They got it sort of renovated to make it old people friendly. It was disability friendly and all of that, very safe for old people. So they two people lived in that house, and the rest of his property he just sold off and distributed it while he was alive among his 5 daughters. After 6 months, this man passes away, willing the house to his wife, and the daughter who one of his daughters lost their husband, so he will, and then his wife willed it to her. What happened is after both of them passed, they passed with very good old age, but the children were very comfortable. They came, they prayed for their parents, they did the cremation and went home. There was no fight, there was nothing, because everything was taken care of during the lifetime. This is another example of over planning, overthinking, and sort of taking care of things even after people pass away. And the third is the story of a young couple who where there's a husband and wife. The husband passes away, the wife is the only one with the property. She thinks the property is going to come to her, but it had come to her through her father-in-law and mother-in-law had gifted this property to her. So it was definitely a question as to whether she could get it or not. So there's a lot of questions around these things. Who's going to be the heir? Where the property comes from? So Hindu law, if the person who's passing away is a Hindu, is very complicated in those respects. It is not very obvious. We always think that, oh, if the husband passes away, the wife will naturally get the property. That is not the case. So these are the things that we need to take care of. We need to look at. These are different situations. Each one of them, somewhere somebody did things and got everything sorted. Somewhere people were just victims of the situation. So as estate planning lawyers, it is our job to understand the family, understand what is their requirement, understand how many businesses they have. Now, if people have businesses, to add to this, they will need to plan not just the succession in terms of shares, but also in terms of who's going to run those companies and how do they plan that. That is a part. So if there are two brothers running a company, I always advise them you should have a shareholders agreement which very clearly says which heir will have how much of shares, or if one of the brothers passes away, on what conditions will the heirs get the shares, things like that. So these things have to be discussed and in advance agreed. Despite them being uncomfortable topics, it is better that today we deal with it rather than spend time tomorrow. So just I think we should move to Nitin now so that he can speak specifically about what are the issues and what are the ways in which one can plan for immovable property. And then I can also sort of speak about how shares and mutual funds and all of these assets can be dealt with. So over to you, Nitin.
Thank you, Archana. Taking forward from what Archana mentioned, it is extremely important is the A, awareness, and then A, B, implementation. When we talk about awareness, today is with the world of AI, today with the world of Chat GPT and Google, when we get multiple answers and Q&A is being responded by many people. Are they really sufficient enough? Are they correct? I'm not commenting on them, but what I'm saying is, for you, for your estate planning, it is your asset what you have created it. You need to define your purpose. You need to define your purpose of in living and enjoying the estate which you have created, and you should see how it should dwell upon. Neither a lawyer or tax advisor should really come in the way of your purpose. They should be enabler to the instruments by way of effective planning, but the purpose needs to be defined by you. Moving from the purpose, taking first step of a common people, what they do is moving into the will drafting. Few broad items of a myth. I'm just trying to talk more about the myth so that it helps you when you are thinking in that direction. Whether stamping of the will is required. Under the law, stamping of the will is not required. It does not need to be even typed or printed. It can be a handwritten, simple will on a piece of paper. The second thing is the registration of will is required. Very often I've been asked this question. No registration of will is required. In fact, there are times where people are very conscious to preserve the confidentiality of their estate. Once the will is registered, it may to some extent is in the public domain. So, second question, will is not required mandatorily to be registered. The third thing, which many people in the normal common parlance takes joint will versus mutual will as a same common terminology. Both are completely different. While joint will looks to be great because most of the assets are created jointly in the joint name. Having said that, once the will requires in particular states to be probated in like states like Calcutta, Bombay, Delhi, in such situations, you also need to probate your will by the legal heirs or the beneficiaries or the executor. So
Nitin,
therefore,
can you help us understand what is the difference between a joint will and a mutual will? Sorry,
yes, definitely.
some basics we don't understand those.
So joint will is when A and B, the spouse who have purchased the properties together, who have created the assets together, they draft one single will. It's called a joint will. So once the will is drawn up, if anything happens to A, the will cannot be altered. If B decides tomorrow to do some distribution of the assets, it becomes extremely difficult because the will partially comes into force in joint will. When it is a mutual will, means it's A and B, while they would have created joint properties, they will prepare two separate mutual wills. So if anything happens to A, B would still continue to operate and can alter its own will, and only A's will come into force.
So the joint will is basically a very bad idea, right?
That's correct.
Okay. Yes, please
Moving
go.
to the fifth point of myth on will regarding the medical certificate. It is not necessary to attach a medical certificate, but one of the condition of drafting and drawing up the will is two persons should be of a sound mind. In current times, with the challenges and the disputes acrimony between the family members, to make sure that will test the proper authenticity in future, one should attach a general family physician certificate to say that will was drawn up while the person was of sound mind. The doctor may or may not know the contents of the will, but he should know that the will has been executed when the person was sound mind. Moving to the second part of the estate planning is on the gift side of it. In the gift, the two necessary elements are extremely important to consider. One is the two witnesses are mandatorily under the Transfer of Property Act to witness to the gift deed. Sometime when you go for registration, the sub-registrar may look at it, may not look at it, but the gift deed must have mandatorily two witnesses. The gift is not valid if it is not witnessed by two people.
So, okay, 1 minute. Let's just pause this. So we've discussed the will, and you mentioned that registration is not necessary, stamping is not necessary, joint wills are different, mutual funds are different, and there was one more point that you said.
A medical certificate.
A medical, correct. So medical certificate, it's good to have, right? So good to have.
Yes.
Perfect. So now,
thank you for well summarizing.
So the gift, is it a substitute to the will, or why will somebody choose to give gift instead of will? So, or should both be necessary? What is this?
Excellent question, Bhuvna. So both operates at completely different purpose. I'm going back to purpose a bit, because will transfer and give effect to the estate post the demise of the person, whereas gift gives a effect of the estate on immediate basis. So that's the major fundamental difference.
Got it. And gift is it's transfer of the asset, and you have to register it and pay the tax and everything, right?
Yes, stamp duty and all.
When inherited, then there is no need to re-register the property, right?
Correct.
So you can save on stamp duty if it is inherited, but if it is a gifted property, you won't save on stamp duty.
That's correct. But for the inherited property, it needs to be drawn up and registered by way of a family arrangement.
I see. Okay, so that's another thing altogether. Okay, let's finish gift and then we'll go to. So there are questions from the clients also here, and they are very relevant questions. But I'll let you finish talking about the gifts, and then we'll come back to this.
So in gift, one common thing which I've often realized it, and it feels sometimes pain to go through those case studies, is basically people come and say that we have given everything to our son, daughter and all. Now we are at 55, we are at 60, and the circumstances have developed such that they are asking us to leave the houses. And they keep searching, Googling about it, take the help, go to the court, etc. So one of the things can be considered in the will is the conditional will, a conditional gift. I'm sorry, not will, it's a gift deed. So conditionality, as long as the condition is legal and valid, should be put in the gift deed, while even giving effect to the property on immediate basis, that the caretaking or well-being or the person should continue to be allowed in the house till the person is alive. So this is limited aspects on the gift deed I wanted to touch upon. The third thing I wanted to touch upon was related to the trust deed. In the trust deed, one limited portion I wanted to touch upon is when you are drafting the trust with all good intentions, the revocation of trust must be considered, must be think appropriately, because there could be times where what you have today created for trust, years down the line, you may want to revoke the trust or dissolve the trust. So those conditions are extremely important to consider as a pros and cons while drafting the trusted deed.
1 minute. So Nitin, 1 minute. Sorry.
Yes.
I'm just stopping. Okay, so under what? So I understood gift deed. If you want to give away the assets during your lifetime, then a gift is better. But hold it and then give away after your lifetime, then the will is better. Under what circumstances is a trust useful and suitable?
So trust becomes a completely separate legal entity, and it holds its own ownership for the beneficial purpose. It has certain tax advantages, as well as it gets ring fence in case of a personal liability which are attached to a particular person. It does not travel up to the trust, and trust creates more like a ring fence boundary for those assets which are created under the trust.
Okay. So
trust are, just to add further to it, many a time there are minors for whom the trust have been created by keeping the executor involved for monitoring the benefits and giving the benefits of the trust to the particular minors for whom the trust has been created.
So trust is for a specific beneficiary. So that's what you're saying.
That's correct.
Okay. So give me some instances of when a trust should be created, can be created. Is it worthwhile going through that effort?
So there is a estate which is worth a few crores of rupees, which does not require to be disposed of at this moment. But if there are grandchildren for whom you want to gift because your children do not require it. They are well to do, well settled, well in job. They don't require your money. So for emotional purposes, the grandparents wants to consider to create some kind of a corpus for the benefit of the grandchildren. So many people do consider for creation of the trust for their grandchildren.
Okay. So I know one financial advisor who specializes in financial planning for parents of children with special needs. So that was also one use case where I keep hearing him talk about creating trust. Is that a relevant use case?
Yes.
Yeah, Archana?
Yeah, I think that's so. I was also going to come to that. It's also very situational. So, this is a very good example, Bhuwana, of a situation requiring someone else to administer the property in the absence of the person who wants to administer it for the beneficiary. So, if I like, for instance, this is also very relevant where you find that a family is separated. So, if there's a divorce, the husband may want to ring fence his property so that tomorrow the wife does not claim it, or a lot of it does not go off as part of the alimony or whatever it is. So these are the situations, like you said, where somebody else is given the right to administer, to execute, to take care of the property, and the person whose property it is goes on the sidelines. He settles the property and leaves it to the executor. And what happens is, once the beneficiaries, if they are minor, once they come of age, the trust itself will tell you who will get what. So we created trusts where the daughter wanted to study law from some place in the US. The son wanted to learn car racing. I mean, whatever it was. So specific funds were allocated. The trustee was allowed to deploy those funds, say when the girl becomes 21 or when the boy becomes 18. So this kind of specific instructions can also be put in the trust deed. And like Nitin said, it is worthwhile taking that effort where the properties in question are worth a few crores, or where the parties are away. I'll give you a very common example in the urban situation today. We are people with aged parents. Parents are somewhere in the interiors of India. The rest of our family is all abroad. Nobody is going to come back and take care of the children. So the nuclear families, how do you handle them? Let's say something happens to a husband and wife with minor children. Who is going to then manage those kids and their life? Right? Who's going to manage the assets? I may have a lot of assets, but I may not have anybody in my family who can be trusted to take it up. Like, let's say the husband and wife are taking a flight and God forbid they don't make it, so these are the situations where if both parents are not there, then the children, how will they be taken care of? The rest of the relatives are abroad. They are not going to come to India and take care of the children, or vice versa. You are abroad and your actual immediate relatives are in India. So these are some of the situational things that you need to consider while making a trust. And also, where, like Nitin rightly said, you want to ring fence, you are having a dispute in your company XYZ, so you want to ring fence yourself, make sure that there's some part of the property that doesn't get pulled into this whole dispute or into the whole dispute settlement process. So therefore it will be dependent on each situation, each person's different requirements, and trust can be very comfortably tailored to that effect. So long as the beneficiaries are named and specific people, the trusts are very effective instruments.
But finding a trustee is a challenge, right? You can make a trust, and of course the beneficiaries are identified, but how do you identify a trustee?
So there are enough and more people today who are practicing. They take a certain fee which comes from the trust estate itself, and they do become professional trustees. The other way is for you to manage the trust yourself as a trustee for some time, and maybe have some create a board, like your friends or someone very trusted to be on the board of trustees and take care of the property. So then they work with the property as if they are a company. They pass resolutions, they decide what is whether to sell, whether to buy assets, that kind of thing. But there are professional institutions that take up the role of a trustee.
Okay. Interesting. So we did a podcast with a professional executor of the will. So this is also interesting where you have a professional trustee, right? Okay. Because Mr. Mani is just asking, the more important along with will is to support the non-resident children in managing the assets and disposal of the assets at its right value. So when children are living abroad and they're not going to come here and sit 6 months to probate the will and all that stuff, right? So execution of the will. So when Nitin was saying, okay, will likh diya, but that does not necessarily mean that the assets have moved on. There's a lot of work after that. Right? So Nitin, you want to answer this particular question? Non-resident children.
Could you just repeat the question once?
Yes, along with the will is to support the non-resident children in managing the assets that are here in India and dispose of the assets at its right value and all that. So that is the professional executor's job, is it?
That's absolutely correct.
Okay.
And therefore you need executor.
Can I expand on that?
Yes, sir. Yes, sir.
I have come across number of people who have assets over here and the children abroad. These assets, the value of the assets are not visible to the children. So the children abroad, when they have to take a decision on these assets, these are all called NRI assets by the local, the so-called local people, and they have an eye on these kind of properties. And when the children are not given, they are given short shift on that. Whenever they come, they want to get it settled within a month's time or within 10 days time. So the whole thing is done in such a way that the real value of the assets are not transferred. Number one. And number two is, till such time the children comes and take possession of the assets, this whole assets, the management of the assets has to be continued. Otherwise, the whole thing is people here, they know how to get around and take over the assets without. And when the children comes here, the assets, there are no longer any assets left, and they will not fight any legal case. So the assets gets lost. So these two are very important things, more than a will. These two are the very important for any succession planning.
Right, sir. Yes.
Am I making myself clear, actually? Because this...
Yeah, you're right. Mr. Mani, you're absolutely right. See, we recently did one case. In fact, we're still struggling with this, where the NRI has agricultural properties in Karnataka, huge agricultural properties. He has never claimed it. He got it from his father in 55. He doesn't have the documents for those properties. And his nephew is tilling the land today. And as a non-resident, he is today non-resident because he is American citizen. Most of them think they're NRIs, but actually when they very happily accept citizenship, and their entire legal relationship with India changes. So that's an entire separate discussion. But having said that, these are other issues that we face where non-residents don't come forward to take their property. People are encroaching on the property. So in those situations also a trust or some kind of a professional agency to manage the property is important. But that's not strictly speaking estate planning. Like I've seen a lot of this in Bombay, you see this a lot. A lot of the old people, the old Bombay residents who have tenanted properties which have become their own property, they incorporate a company and everybody gets shares. They have flats, they have 10 flats. 10 flats equivalent shares are given, and then it's the shares that devolve on legal heirs, and then if you have the shares, you can live in that flat. So these are also some structures that we have seen, but again, each one needs to be evaluated depending on whether it's urban, where the properties of the non-resident are. So in villages, how do you get the records? The records are you go and check for revenue records. They are not really title. Sometimes government may take away some land. So how do you protect all of this? So the answer is that you need to, at some point, somebody needs to come down, spend some time in India, consolidate all of their assets, and then put it all in one bucket and decide that okay, this is how it's going to be built. Most non-resident children don't even want Indian properties. They say we don't want the property, we don't want to get into fights in India, trying to spend, like Nitin said, 6 to 9 months in getting a will probated. So we don't want to do all of that. So how do you help them is really a question. But what do you do with those properties? They are physical properties, physically available. I mean, it's not going to go away, right? So these are some issues that you do face, and if people come early on to either to lawyers or to other financial service providers, some solution can be found during their lifetime.
So this is a very interesting thread, and then this particular podcast that we did with this professional executor threw a lot of light on similar cases. Like, okay, you wrote a will, and then what? After that, a lot of issues about the house help just moved in with all family and everything after the person passed away and refused to move out, right? So the executor had to bring in the police and then throw them out and then sell the property. But Mr. Mani, I think probably a good solution would be when you write the will, name a professional executor as an executor in the will, right? Archana, does that make sense?
Yes,
Yeah.
absolutely.
Name a professional executor. That's probably a good solution. So there was one more question.
Finding a professional. Yeah, this is also another question mark. See, I
A
know
professional
cases
executor, if you want some recommendations, I can give you, Mr. Mani. We have
Okay.
in our network a few people.
No, it has to be seamless. The will, if you are succession planning, if there is a will, it has to be, like I was looking at, your last time when we met, we had an idea to form a trust and things like that. So trust will be a best thing for, see, each individual, right? We have single children. So single children, there is no need for I mean, in my opinion, there is no need for a will actually, right?
So this is a question. So I have only one child. Do I really need to write a will?
Yes.
Nitin?
The purpose should come out of the person who has created the asset. This has a lot of conditionality. Instead of giving answer in yes or no, I really want to know what are the worth and what are the estates and whether the child is married, unmarried, have kids. So these are the multiple things which one need to consider for drawing up the will. It is just not a very simple answer just because I have one kid or he's abroad or he's in a good job, whether I should have a will or not. Yes, it all depends upon the external circumstances to determine the safety of the estate during the lifetime and also giving a effective assets to the child and the subsequent family members.
So would it make sense for Mr. Mani to talk to you directly on his specific case? I think that would be a better idea, right? So
Yeah, it is. It's basically
Absolutely.
see, for me, it is my son is an NRI and not resident US citizen, and he's well settled actually.
yeah. So can you please talk to him directly about this? Maybe he can help you, sir.
Oh yeah.
Yeah?
Okay. Sorry, yeah, whether it is needed, basically, first of all, whether it is needed actually, because whatever we have, he is nominated as a nominee, so there is no question about should we go ahead with a will?
Is it needed?
So,
do I need to do any succession planning at all, or should I just let the law take its course?
So nominee versus succession, I will request Archana to first see the latest recent Supreme Court ruling on this, which will be more like an eye-opener or more like a recent development, which has also cleared some of the post-judicial pronouncement, the anomaly between the overall company law security market. So Archana, would you like to take first nominee versus succession?
Okay.
Sure. So, nominee is typically somebody who is going to hold the property as a trustee. So this is the answer to how does the property get managed in the absence of the owners or after they pass. So a nomination usually helps where immediately the property can be taken control of, but the nominee doesn't become the legal owner of the property unless they are declared. So I'll give you an example. For maybe real estate, the way it works is that I'm a nominee. I go and tell the society that I'm taking control. So society will not do anything with the property, will not give it off to others who are coming as legal heir without checking with the nominee. But does that mean the nominee is the owner? Answer is no. The nominee has to have some kind of a legal heirship document or some kind of a succession document to get this on record. So there are a lot of societies where I know that if they know the people involved, they will just quickly transfer the property or the shares, but that's not always correct. And in most cases, societies will ask for a probate or of a will. So this is one. Second is in terms of bank accounts, mutual funds, and other things also, the law is very established that a nominee simply gets the right to keep the property so that it doesn't go off into some kind of unused or those investor protection kind of funds. That's the only advantage of having a nominee. But those nominees, they do not automatically become the legal owners of, say, the mutual fund or say bank accounts, etc. Now, what happens for shares? Earlier, as far as shares were concerned, there was a very clear understanding from the Companies Act that a nominee in the company's register will be the owner of the shares. It was pretty clear. They would say that there was a section which said that the shares would vest in that person. So we used to always advise our clients that as far as shares are concerned, you nominate and leave it. But for other things, despite having nominees, you must have a will, so that you can protect your property. You can make sure that it goes to the right people. But now that position has also changed as of December 2023, where the Supreme Court has actually said that it has read the Companies Act provision to mean the same thing as a nomination for a mutual fund or a bank account. And they have said very clearly that the Companies Act does not intend to create ownership struggles, just wants to insulate the company. So therefore, even if the company registers the nominee in its books as the registered owner, the beneficial owner would still be the legal heir. So
Which means the nominee cannot sell, right? So they cannot.
Nominee does not have the right. If they sell, whatever proceeds they get from that sale, they are holding as trustees for the final legal heirs. So nominees have rights, but they cannot keep the benefits of that asset.
But if your own children, like if your own son and daughters cannot hold they require a will to have the property transferred to their name.
In terms of real estate, answer is yes.
So, Mr. Money, if there is no will, society will also ask something called letter of administration. So, if you have a will under the court terms, it is called probate. If you do not have a will and it needs to pass on to the children, it is called letter of administration. Both are granted by the respective courts.
So either which ways you have to do this court business.
But once you have a will, which is this needs to be probated before any transfer, or it can writing a will itself is sufficient.
Answer is no. Depend upon which states the will has been executed.
If it's Maharashtra,
it is to be probated.
Okay. So this probate, the will has to be probated. Otherwise, if there is no will, there is the letter of administration, which also has to be issued by the court. So there is this to the court that has to happen before assets move on to the next, to the successors.
So how do we do something without getting into this kind of will and probate? So that's why the the trust formation will work.
Family settlements, will they work?
So it either operates as a gift deed or it will operate as a trust in this situation what Mr. Money is explaining.
Okay.
So if I can just add a little bit on family settlement. See, family settlement works in situations where there is complicated, sort of descendancy of properties, where there is a joint ownership of property like a HUF, or where there is a, ancestral property, and things like that. Family settlement works very well where people are mutually relinquishing rights. I say, okay, I will give away this. So if we are all entitled to this large property, I will give away my right to your portion. You give away your right to my portion. This is how these family settlements typically work. In India, the good news is that family settlements are given a very high regard in court. So if somebody were to show that a certain property has been divided in a particular way through the family settlement, then the courts will take care of it. But that's still not going to help you posthumously. This is something that is going to help you to deal with a large ancestral property or a large, some kind of property which has just been left with multiple owners, multiple legal heirs, the cross holdings and things like that. So to sort of remove all those anomalies, you can have a family settlement. But even after that, as far as each share is concerned, you will still need to plan your own heirship and your own estate.
Nice. Okay. Okay. So family settlement is not again a solution to what Ms. Mani is saying.
No.
Okay. So is trust a good idea
No.
in this circumstance?
Trust should be a good option, but see, if you look at it practically, if you have only one child and you are all your properties, the child is a nominee, just a simple will saying everything I own belongs to the child, belongs to my kid, to the exclusion of everybody else in the world, should be sufficient, and that will just move things fast.
And how long it will take for probation? Whether it will have it's a complicated process or whether it is probation is much easier.
It's a process by the court, so it takes anywhere between 6 to 9 months. And there is a fee involved, which is called court fees to be paid. Based on the value of the property, maximum court fee is capped at 75,000 rupees.
All right. But what about the trust? Whether in this actually the question is whether to form a trust and then it will continue. The trust will continue. But the children are non-residents, so they are US citizens. So how do you run a trust in India with the US citizenship?
So, Mr. Mani's raised a very important point, Bhuwana. I was going to come to it. Non-resident people have to definitely they need to take advice on property devolution, on getting shares, etc. Because in many cases, those things may not be permitted. The law itself like for agricultural lands, the only way a non-resident can get agricultural land is through inheritance. They cannot acquire agricultural lands in India. So there are a lot of times when RBI has gone against people and said, oh, you've tried to, as a non-resident, you've tried to acquire this agricultural land, or it's a sector which is very highly regulated and foreign investment is not permitted. Let's say I have shares in that. Those kind of sectors also, if the beneficiary is a non-resident, there are going to be issues in getting that instrument registered in their name. So this we do this also, we always advise our clients from a FEMA perspective also, whether something is permitted under the RBI regime or not. So definitely for non-residents, the treatment of bank account, what monies can go out, which bank account to use, all of these questions need to be answered.
So you're saying
more than that, there are there are certain angles which need to be looked at. Number one is the taxation angle. Number two is a declaration, because once you bring non-resident children into your trust, they have to declare all your assets into their income, whatever is the trust, their shares and things like that, and it goes on into that, and they have to pay tax on that. That is a very huge question mark. Number one. Number two is they have, when there is an inheritance and when they get the money, there's some $15 million can be exempted from tax from the inheritance, and remaining and all you have to pay tax on that. So these are all things which need to be looked at. But prima facie, it is when you have a trust, the trust when the children, non-resident children comes into a trust, in the trust, they will have to show it the entire property as in their FBAR and in their tax returns, and I don't know whether how they will have, whether they have to pay tax or not. This point I am not very clear about it. Maybe we have to I have to go through it little more in detail actually.
Archana, do you
Hello?
have any answers on that question or?
See, I would always say that you cannot, beyond a point, oversimplify things. There are certain factual scenarios that change answers. Like it could change the answer drastically. So in every single case, the facts are very important. So it cannot be generalized, or the impact cannot be discussed in a very simplified manner.
Point taken.
All right,
Okay.
point taken.
Understood.
Okay.
Perfect. So I have one more question from Porus. He's asking me, in case of a property jointly owned by me along with my father and my wife. So he owns a property with his father and his wife. Given the long time required for the probate process of a property in Maharashtra, would it be prudent for my father to gift his share of the property to me and my wife? That's a
So he can gift the share to either of one person.
okay. He can gift
His
his share to either one of the people.
That's correct.
Execute a gift deed and register it and pay the stamp duty and get it done.
Right. And there is a concept of share also, tenants in common and joint tenants.
Okay.
So from the last thread, Bhovna, it is important that when the people are registering the property in the joint name, buying the property or taking a house loan in joint name, if they wish to put the percentage of the property, who owns how much percentage, becomes very easy for relinquishment and release in future perspective. Most often, out of 10 documents, or 9 documents are silent on this aspect of distribution of percentage. Therefore, it is divided as equals 50-50.
I see. Okay.
If the purpose is just a mere name adding, many a times we come to know that people say that it was done at that period in that good intention only to keep a name for name's sake. But when you say only for namesake, and if you do not put the particular distribution within the sale deed itself, it becomes equal. Otherwise, it needs to expressly captured in the real estate document.
I see. Okay.
Okay. Yeah, thank you. Thank you, Nitin, for the answer. I just have one more question related to this. So, can my father divide his share equally between my wife and I? Or does he have to give it only to either me or my wife?
He can divide the shares, his
Okay.
share.
Sure. Thank you. Thank you, Nitin.
There's one more question Porus has asked. In case of a demat account that is jointly held by two people, partners, and when one of the spouses passes away, does the surviving spouse need to open a new demat? I don't know if this is a succession planning question, but do you know what happens to the remaining share? Does it just come to this person? Because there's a little bit of confusion on either or survivor in a bank account and a joint ownership in a demat account. Are they the same? Are they different? What is it?
See, in bank account also, you could have an either or survivor, in which case the survivor gets the rights, or you have basically a joint account which is either joint and it has to be closed if one of them passes away. So it can only be used jointly. So only like two people need to sign it. Like for instance, this happens when you have partnerships, like an account for a partnership. The partners, both of them have to sign. So this is the difference. But in a demat, the situation is slightly different. As a person, I can only, the demat is like a separate entity or separate identity, So if A is the owner of the demat and B is the joint owner, it is basically both of them together. This is like A and B. There could be A, there could be B separately, and there could be B and A. These are all treated as separate accounts in the eyes of law. So when one of them passes away, many depositories will have in their conditions that the first owner is treated as the owner. Some depositories will tell you that both are treated as owner. If one of them passes, you have to close the account. So you will have to check the terms and conditions of your depository, the one with whom you have opened an account, as to what is going to happen, because there is nothing stipulated under law. They are only required to make the disclaimers, but it's not stipulated under law.
Wow.
Okay.
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 I never realized that every depository can make their own laws around
Yeah.
this.
Not the laws, but they can make their own consequences of how this is going to be treated.
Wow. Okay.
Okay. Thank you. Thanks.
Interesting. Okay. So on the side, Amrita is asking, what age should you be making a will? This is a very common question.
So I would say that age in today's post-COVID, I think we all have answers with us. What is the uncertainty in which we are having? Having said that, it's still, if someone is having an asset which has been created over and above your normal utilization as a more like a future investments, future kind of a creation of a pool of investments in different buckets, then one should consider it. And when the at least they have they are married, or they have children who are minor, they should consider it at that point in time.
So married and people with children, of course, there are some laws around that, right? So there is a succession law that says, okay, the assets go directly. There are legal heirs who can be identified. What if somebody is not married? There is a single man, single woman, and they have a lot of assets that they have accumulated. Then
Archana?
So it is very interesting. It's not always logical. So Hindu male who dies intestate, doesn't have a family, it will go to his next of kin, and there are lineal and there are lineal descendants, and there are ascendants, and there are different categories of people. Basically, long and short is that it will go to his parents. And if his parents are no more, it will go to all those people who would have been legal heirs of his parents.
okay.
So this is how it is. See, the succession law is not very logical. Okay, most laws are very, very logical. You will be able to understand it, but succession laws are not really logical. It's based a lot on Hindu customs, usage, and all that. Similarly, it depends again. Like if someone, a lot of times in law college, we to trouble our professors, we used to ask this question: if I'm a Hindu and I acquire a property, then I convert into a different religion, then which part of the succession law would apply to me? But these are real issues. So if a Hindu male died intestate, but before dying he converted to Christianity, would the part of the succession laws that apply to Christians? So there are different laws for each different sect. So all of those need to be taken into account. There is no one answer. It's interesting to know that if you want to give away a portion of your property to charity as a Hindu, you need to do it. That will needs to be 1 year before the date of your death. So in the year of your death, if you write the will, you cannot will to charity. These are some things which are seemingly, without logic. Similarly, a Hindu woman, it's very complicated. When she dies intestate, a Hindu woman who's married, you will think that it's logical, it will go to children and husband, but no, that's not how it is. The property will be divided. You will see which property has come from maternal side, which property has come from husband's side, and then accordingly it will devolve. So it's not always open and shut. We get a lot of cases where we have to give opinions on whether or not which part of the property will come to them. Like it's a whole building, they have kept constructing on a piece of land owned by the father. Each son is living in a different floor. How will the property devolve? What is going to happen? So these are all things that need to be studied on each case, and that is why we are always afraid of interstate estate planning, because it is you're leaving yourself in the fate of law. Maybe in your case, sorry,
and a not so logical law for that matter.
not so logical law. Nitin is doing one case where there are people who are claiming the property, where under Hindu law we actually found out that they don't have the right to that property, and they were shocked because they were the closest to the people in terms of relationship. They were the closest to the people who passed away. So this couple was shocked to find out that they were not the logical heirs and they had no right under the Hindu law.
Wow. So if you the long and short of the story is that if you have assets beyond what your regular needs
Yes.
are, and if they can be useful for somebody, please think about it. Please at least give it a thought and write it somewhere or consult a succession planning, a lawyer or somebody, and have a plan for it. Right. So that is what you are saying. So that's fantastic. Okay, great. So Amrita, I hope that gives you some answer. Satya's question is legal help on estate planning. Should advisor be local to state? Say for advice in conflict in Tamil Nadu based property, can I approach a legal advisor from some other state?
Nitin, you want to take that?
So this is a very pertinent question. While the laws are all central laws in terms of dealing with the estate planning, but for as far as the distribution of assets, the moment you plan and decide the structure for execution, you would require a local help because certain procedural formalities are different state-wise also.
Okay. So when it comes to writing the will, you can get it written by anybody. But when it comes to executing the will, you need to have a local lawyer or advisor. That's what you're saying.
Yeah, sometimes the vernacular language will also be important. Sometimes certain documents will be in a vernacular language. Some local sub-registrar will have a different requirements as per the procedure of that state. So for such kind of stuff, it will be always important to take a local help.
Great. Thank you. Thanks very much, Nitin, for that answer. There's one more question from Binu. Does succession planning also include tax advice on inheritance? So are they two different things? Do lawyers do that? So what is it?
They are yin yang, basically.
Yeah, they go together?
They go together. You cannot leave the one and decide the other. Extremely important. While you want to do the things are that I may think that tax is most important for me, but when I started with the statement is if my purpose is not achieved and it's a mere saving of the tax, I may not want to just do a tax planning. But at the same time, if legally I have some solution, but it's a very heavily taxable options, I may want to explore something else. So both are absolutely go hand in hand, and one must take a comprehensive advice.
Must take a comprehensive advice. Okay, fantastic. And does the succession law differ for shares and mutual funds between a resident and a non-resident? Is it different? Are the laws any different for resident Indians, non-resident Indians? Because taxation is different for resident Indians and non-resident Indians.
No, so the answer is no. Most laws allow you as a non-resident to get in succession property from someone. So, like for instance, I think for shares, it is that for mutual funds, I don't think it matters because anybody can own mutual funds if they are allowed to. Like for instance, if you have a demat or whatever, you can own the mutual fund. So for mutual funds, there's no problem. For shares, the law typically says that if you're a non-resident and you get it from your immediate relative, like up to the grandfather, then you are okay. But like for an uncle gifting, you'll have to check whether you need RBI approval. So this thing needs to be checked. The law, and to be honest with you, the law has changed at least 10 times over the last 5 years. So at the time the transaction is to happen, we need to double check what is the permissibility. For property, again, non-residents, there are certain non-residents cannot purchase property, but they can inherit property in India. But even that inheritance, there is a certain limit. So you cannot sell that and buy another property. You could probably sell that and repatriate the funds, but you cannot sell it and buy another property. So there are a lot of restrictions on the use. So definitely at the time of the succession, at the time of trying to take control of the assets, one must examine this aspect from the RBI perspective.
Interesting. So that is how it is talking to lawyers, right? You don't really get a this or that answer. There is no black and white. Tell me this or that. No. It could be this law, it could be that law.
Yeah, it cannot be, because I'll give you just a funny story. So we were trying to do the takeover of a listed company, The promoter had, it was 4 brothers with some 8, 9 children, and there were some 62 shareholders from whom the investors had to purchase the shares. Now, each one of them emotionally has gifted shares to their daughters and things like that. The daughters were resident at the time of the gifting. After the gifting, they became non-resident. So isn't that also part of the estate planning? Now, how does my daughter sell and realize her shares? Because she cannot do it. RBI said no. RBI said you should have declared at the time that you became a non-resident that your DMAT is actually a non-resident's DMAT account, but your DMAT is a resident's DMAT account and you are a non-resident. So I am not going to allow this transfer. So we had to go and cajole the RBI. We had to go and make because there's a whole takeover of a listed company at stake over there. So these are the kind of things that people have to keep in mind. A lot of times people don't designate their accounts as resident or non-resident. That's very important, because if you don't do it, then when you try to repatriate the funds, or when you try to realize the value of that asset, you won't be able to do it. Now for this to happen, it's not a posthumous thing, but during the lifetime, trying to realize assets which have come to you, say as a wedding gift or something, even that becomes difficult if you don't take care of these kind of laws. And to answer your question, why lawyers don't say it, 1973 we got a foreign exchange law. 1999 it got changed. 2017 the central government said to hell with everything, and they changed it again. So your property you may have received between 1973 and 1999. You may have received property after 1999. You may have received property after 2017. In each case, the answer will be different.
Wow. Okay.
So it is.
Now I sympathize with you. Okay. Good. Okay. Interesting. So that is amazing. So I'm sorry, I introduced all of these questions while Nitin was at something. He was talking about some part of trust or something, and then I started interjecting with all these questions when Mr. Mani's question came up. So do you want to pick that thread and complete it, Nitin? If there are any more questions from our audience, I would, we can ask them. We probably have another 10-15 minutes. So feel free to put it directly in the, everyone in the meeting in the box, chat box, and then we can, get them to answer. Yes, Nitin, on the trust, you were saying something.
So moving from the trust, basically, I wanted to differentiate and touch upon some aspects of a release deed. Many people have not either heard of this term and do not understand the difference between the gift and release. So the release deed basically operates as a relinquishment of your right in something what it exists. So I would again give an example of a A and B spouse. So if the property is jointly owned by AB, or maybe with the one of the parent with C, so they decide to have a relinquishment of right, they may not need to gift the property. They can also, because in gift, what is the consideration involved? Under the gift, the consideration can only and only be natural love and affection. There
Correct.
cannot be a money involved under the gift. Whereas in release deed, when you already exist certain rights, you can exchange and release those rights qua the commercial consideration involved. So I may release my rights against the value for that particular share and get a release of my rights. So that sometimes helps when you are looking at maybe 2 brothers are having an estate created for certain contribution at those times, and one needs it. So he may release his rights into the property by taking certain portion as consideration legally under the document and move on, and it will be a proper distribution of the asset by way of a legal instrument of release deed. That's the difference between the release deed and the gift deed.
Interesting. So what Porus was asking, that his father has a share in his property and he may gift it to him and his wife if he wants to, or Porus and his wife can buy it out from his father, right?
Yes.
His father can, issue a release deed if somebody has to be compensated for their share. That's what.
Correct, Bhavna.
Okay. Thanks.
Yeah, Porus, you had a question.
No, thanks for this perspective. Wasn't aware of the concept of a release deed. So
Okay, interesting. What steps does the succession planning advisor firm take to maintain continuity of service since these are long-term based decisions? That's a very interesting question. Today, I write a will, I take your help. I may live another 50 years. Will you be there?
So, could you repeat the question once again, Bhuvna?
Because it's a long-term decision, right? So I'm writing a will, and then it the reason for using that will or probating that will might arise 40 years, 50 years from now. We don't know, right? So then if I'm named an executor in the will and all, then how does that work?
So, one thing is people generally we recommend it instead of keeping more elderly into the will than of your age, it is better to keep more younger people from the family as executors if you are doing from the family, or you do it through an institution where at least even if one moves out, the institution still remains over there. The second part is during the lifetime, if today I have executed the will and circumstances have changed over the period, you may put a review of your will, 3 years period, 5 years period. And what you can do is any updates and major developments can be captured something called an instrument codicil. Through a codicil which operates as an amendment basically of your will. Your will does not require to be touched. At the same time, a codicil will help for extending and updating the will. That's how you can keep your will and the circumstances till you're alive, and when you review it, can keep it up to the latest, to the extent possible, latest and in effect.
That's a very sensible suggestion. Bino, I hope that answers your question. Periodically look at your will and update it. If the executor you have named in the earlier will is not willing to execute or is not available to execute, issue, make a codicil and rename somebody else as an executor. That's what you're saying, right?
Yes, Bhuvna.
Okay, fantastic. I think that is making a lot of sense. So between Archana and Nitin, I think we've learned quite a bit today, understand some myths about wills, about joint holding, about mutual wills, about gifts when it is suitable, about trusts when it is suitable, and about family settlements. So that was, we tried to cover a lot of things. So just cutting it all short and making it very simple, if our clients have to get some kind of a succession plan done for their assets, this is hard-earned money, nothing has come free. They've made, it's their lifetime saving, and I'm sure they have certain purposes and objectives, just like how they make a plan with us and they have a certain purpose for the money. One important purpose is to stay a blessing to people around us, like how Nitin rightly pointed out. You don't want to be a burden, but you don't even want to be a pain, right? Leave behind all kind of assets with all kind of complications. So what is the process if somebody has to approach it? What is step one, and how can we take it ahead? If you can quickly take us through it, and then we can take it from there.
Sure. So to start with, as a step one would be to have all your assets documented in today's time. It's extremely important because we have n number of times seen the situation when clients approaches us. It takes them 6 months to 9 months to put their house in order to collect the documents and digitize the document. It's a very basic step that any and every asset documents which you are holding, be it your insurance policy, be it your ownership estate document or your loan document or any document which is arising or connected with the estate, should be physical as well as digital, designated at a particular place, and your family must know about it. So that's the step one to start with.
Digitize the documents. That is step one. Okay.
Yes. Step two is basically create a purpose of distribution in consultation with your tax advisor, your estate planning institutions, and your lawyers if you have any complications and where you feel that it is important to have a. So define your purpose along with your advisors, and then step three will be to codify those documents and put into the execution with the stipulated timelines and start to execute your plan of succession. Archana, would you like to add a few things based on experience?
Nitin, long story short, come to Agam Law Associates. We will take
Have a
No,
timeline.
on a serious note, when you're choosing your advisor, you need to choose an ecosystem. Individual advisors, I'm not saying don't go to your trusted individual advisors. You must go to them because they know you best. It's like going to your local family doctor, right? But you must trust the ecosystem. So there should be a tax advisor, an advisor if you have non-residents, and I'm sure most people here have either non-resident parents or children, and the different properties that you have. So you should have lawyer, you should have a tax advisor, and you should have a foreign law advisor. Apart from this, what you need is an overarching somebody who has prudence in financial investment, so that your investments itself at this stage is not into risky instruments or into murky instruments.
Archana.
Sorry.
This is us, I said. We are the financial planners
That
here.
is you, exactly. So you need to start there. Plan safely, plan carefully, and like Nitin said, keep meticulous records, and make sure like people don't know their folio number, they don't know their DPID. I mean, these are things that are not excusable, because it leaves the person to whom you're willing everything away. I can have 10,000 Reliance shares, but if I can't find how to get that ownership, I mean, it's of no use to my children, right? So that kind of thing. But also have trusted legal advisors with whom you go openly discuss all your issues, and a tax advisor. Having said that, in India, gifting is a very good solution, because within the close family, gifting is tax free. So unlike there's a common myth that, oh, how much can I gift? Can I gift over 50,000? It is for non-family gifts, cash gifts, that 50,000 is the limit. For within the family, gifting is free, so that's a good methodology. So approach lawyers up, make sure you have your list of documents, and go and make sure that you have your taxation do's and don'ts in place, and then it should all be okay.
So that's fantastic. Happy to take any more questions, but I'm quickly summarizing what Archana's saying. I've written it down for everyone and sharing it here. So put all details of your current assets together. That's number one. Like what we do in financial planning, collect all the information, get all the assets, and put them in one place so you can see it, identify the ISIN number, the folio number, all of that, and keep it in one place. That's number one that you're saying. And then find the purpose for your wealth. That's, I think, very, very relevant point that Nitin is making. What would you like happen to this money? For a moment, take a few minutes to think. If something were to happen today, and today if you were to fall dead, what will happen to all of this wealth? Who should get how much? So think about it, find a purpose. What would be best use of your money after your time? So find that purpose, and then reach out to a lawyer and say, okay, this is what is my objective, this is my purpose, and what is the most cost effective, tax efficient way of doing this, which is of least hassle for my heirs, because I want it to be easy for them, right? So you were saying gifting is a good idea, but whether gifting or whether trust or whether family settlement or whether will, I think it makes sense for them to find an advisor, find somebody who knows the subject, and given your circumstances and your objectives and your background and the resident status of your heirs and all of that, find out what is the best possible solution, right? So that's what we are learning from here, and I think that is making a lot of sense. I mean, because we don't specialize in this activity, and we know Nitin and Archana for some time now, and they've come to fantastic reference, and they're doing good work in Bombay. We thought we'll bring them on the show. Feel free to reach out to them for any of your legal requirements. And if you want us involved in your succession planning activities to put the data together and help you through identifying the purpose and things like this, very happy to do that for all of you. So thank you, Nitin and Archana. Would you like to leave your contact numbers or your website name or anything, how they can reach you, like an email ID or something? Can you put it on the chat, or if you can flash it on the screen or something like that, that'd be great. Yeah, archana@agamalaw.com. Is email the best way to reach you? Nitin
Yes.
at Agama.
Yes,
Yeah.
it is a cost effective.
So drop them an email and maybe reach out to them for whatever help you need. And thank you very much for joining today's session, Archana and Nitin. Extremely gratitude to you for taking this time off on a Saturday afternoon to talk to all our clients here, and look forward to more work together. Yeah. Thank you very much. Thanks everyone for joining us today.
Thank you.
Thank you, Bhumna,
Thank you
and
very
thank you
much.
everyone for being
Thank
a patient
Thank
listener.
you.
Thank you, everyone.
Thanks a lot, guys.
Bye bye.
Yeah.